Hi, I'm Kimberly Robideau, a partner with WR Immigration, and I'm located in San Diego. I'm extremely excited today to introduce and welcome Carrie Koski to WR Immigration as our newest partner. Carrie will be heading up the Denver office, and we're super excited. Carrie not only has years of experience with business immigration issues, but she also has a unique skill set with the I-9 employment eligibility process and the weird issues that arise with I-9s. Welcome to the team, Carrie.
Thank you, Kim. And I'm so excited to be here. I'm so excited to be part of WR Immigration. And it's a pleasure for me to be co presenting with you today because you are a superstar, um, vice chair of the American Immigration Lawyers Verification and Documentation Committee, which advises and workshops issues as they come up. So you really eat, breathe, and sleep this. So this is really, really a pleasure and a delight for me. I'm actually very close to the I-9 process because my first day at WR Immigration was yesterday. So I'm on the other side of it as an employee onboarding. And it's been really interesting because I started the process before my first day. I always tell clients if you can send the I-9 and have them start before. And I'm also using the virtual verification process. So I filled out my section one, I made copies of my documents, and I sent them off to our HR director. And later today, I'm going to have a video conference with her, and she's going to verify. So we are compliant.
Hey, that's awesome. It is totally a geeky world with I-9s, right?
Oh, for sure. And so much has happened in the last 4 years, really. It's really a lot to keep track of.
So I'm glad you're here so we can gather together and put our heads together for all these complicated issues.
Me
So
too.
with that, today we're going to touch on just a few of the I-9 topics that have been on the minds of our HR, immigration, and global mobility team partners. And I'm really glad that we can talk about this today. So in some organizations, the immigration case team handles the immigration case matters, and then they also handle the I-9 and the E-Verify processes. In other organizations, there's an immigration team that only works on the cases, and then a separate team that works on I-9 and E-Verify processes. So, Carrie, what do you tell your HR team members that have this situation where the immigration process, so to speak, is separated between these two teams?
It's actually very common because conceptually onboarding is completely different from immigration. But in reality, the two are linked because the I-9 rules are actually immigration rules. And so it's really important. And what I tell global mobility and HR managers and legal teams is to have routine check-ins, maybe once a quarter for those two teams or three teams to meet and go over any new rules, trends, compliance issues. So, for example, with work visa expiration, your typical H-1B, the I-9 team must actually engage the immigration team because they need a copy or they need to see the I-797 approval notice to complete the re-verification section of the I-9. Another option actually with I-797s is to have outside counsel update the re-verification section of the I-9 because outside counsel receives the paper 797 from USCIS and can do that on behalf of the employer. Tricky legal issues with automatic extensions come up, and those are true legal nuances. We hear about those through publications on the updates on the I-9 handbook manual or through I-9 Central. But if you're not really keyed into those things, you can miss those. And a legal team is typically up to date on them. And so that connection is very, very important. And of course, we're always happy. Kim and I love this stuff. So we're always happy to help answer questions about extensions and re-verification anytime.
And speaking of re-verification, so H-1B cap season is here. We are fast approaching that time of year when foreign national employees may be in a situation in which their work authorization will be extended based on H-1B cap gap. For those who may not be as familiar with this term, cap gap occurs when an employee's OPT or STEM OPT work authorization expires between April 1st and September 30th. If they win the lottery and their H-1B cap registration is selected in March, their work authorization is extended until September 30th so that there is no gap between when their work authorization with OPT or STEM OPT expires and when the H-1B status becomes effective October 1st. So with this cap season that we're in right now, Carrie, are there any unique issues that HR and global mobility teams should be mindful of in these situations with respect to the I-9 process and cap gap?
Yes. This cap gap is a great benefit, but it can also cause work authorization gaps, where people aren't authorized to work. So what I tell my global mobility and immigration team is to flag these cases to the I-9 team. So if you're handling H-1B cap, definitely connect with the I-9 team. And help them update the re-verification section, because not only do they need to include the I-797 receipt for filing the H-1B petition, but they also need to update the I-9 indicating the expiring or expired EAD along with the receipt that the H-1B was actually filed, that 797, because that cap gap is valid through September 30th. And prior to September 30th, the I-19 will have to go back in with the H-1B approval notice and re-verify that section to indicate that that person now has an H-1B and will be authorized to work on October 1st and beyond. If for some reason that H-1B is not approved by October 1st, that employee cannot work. I tell people an unpaid leave of absence would be okay. And this is really the reason why employers choose to premium process cap gap cases, because with premium processing and prioritizing those cases to file at the first instance, once they're selected, you reduce the opportunity for the cap gap. But it happens every year. If there's a request for evidence, sometimes H-1B processing is extended and the H-1B is not approved by October 1st. It's just something that I-9 teams really need to keep tabs on and calendar it, tickler it, sound the alarms on September 30th so you can remain compliant. And one other thing, travel during cap gap, don't do it. If somebody travels during cap gap, they'll likely won't get back into the U.S.
One of the things that I really like about working with WR Immigration, right, is that we have our own case management system, Rapid, which allows us to pull reports for our global mobility and HR team partners in order to say, these are the people who are going to need cap gap, and then these are the people whose work authorization needs to be re-verified by October 1st. So that's a great benefit that we have here with those reports. Yeah, one of the things, right, with re-verification, we know that every re-verification is the same. So we have situations, especially this time of year, where we have F1 students that are now applying for their STEM OPT extension, and their work authorization might need to be re-verified. So how is that a little bit different than the cap gap where we see for F1 students?
That's a great question, and it's actually completely different. And it's a kind of a tricky issue. When I talk to HR teams about the situation, we discuss the STEM OPT extension, which is a great benefit. It's work authorization for 180 days once the EAD card application has been filed. So this benefit, this automatic extension, has to be memorialized in the I-9 by recording the expiring or expired EAD along with the endorsed I-20, which comes from the designated school official. And this may sound like jargon and gobbledygook, but it's necessary to re-verify the I-9. The I-20 may not be intuitive as a work authorization document. It's used for CPT and it's used for STEM OPT extensions. HR professionals should calendar the 180-day benefit after they record the I-20 and the expiring EAD to ensure that they can re-verify with the new EAD within that time. But I think calling out that the I-20 is the required work authorization document for STEM OPT extensions is really important and something to remember. And Kim, can I ask you a question? Yeah, so the I-9 process has been getting more and more complicated given a variety of document combinations and automatic extensions that USCIS has issued over the last couple of years. How do you advise employers to deal with this expanded work authorization and all of the different documentation combinations that are available?
So a very good and timely question. HR teams that are responsible for the I-9 process have really had their work cut out for them the past few years. And one of the reasons for that is that USCIS has been cleaning up their backlogs that resulted due to COVID as well as the prior administration. So with trying to reduce the backlogs, they have come up with some creative ways to allow for automatic extensions of documents as well as to allow for different types of documents that may be accepted to prove an individual's work authorization. So for instance, the employment authorization document card, or otherwise referred to as EAD cards, have been in a situation where they have automatic extensions for 180 days when an extension or renewal application is submitted by the individual. So that was fantastic. But it wasn't enough, especially during, certain period of time of COVID. So the government increased the automatic extension period to 540 days. That was because they were just having a really hard time to produce the EAD card applications. Well, then at the end of October 2023, we went back to 180-day extension. What that does is it creates a roller coaster, right? Employers like 180 days, 530 days, 180 days. So it gets really confusing. There are also other documents that the government, USCIS and CBP have put into place that allow for work authorization for individuals in certain programs like the Afghan Adjustment Act, as well as United for Ukraine. So given all these different documents, we have calculated that there are more than 40 documents that may be acceptable for employment authorization verification that are listed on that list of acceptable documents, which is, that document together with the I-9. So in light of that, all these documents are referenced in the M274 Handbook for Employers Online, as well as USCIS's I-9 Central. But it can be really confusing and very complicated. So we'd like to work with our HR team members who reach out to us to ask about certain documentation to determine if it's acceptable, rather than turning an employee down. Because if they turn an employee down, they could run afoul of the Department of Justice's Immigrant and Employee Rights section for citizenship discrimination, national origin discrimination, or if they ask for additional documents, they could be accused of document abuse. So it's really important to kind of have a handle on those documents and just reach out to those who are familiar with the additional documents that are not on that printed list of acceptable documents. So that's been fun.
Yeah. Yeah, it's gotten really complicated. I mean, on one hand, you have the opportunity of expanding work authorization for so many people. And then on the other hand, it's just, more compliance steps that employers have to take.
Yeah. So what have you been discussing, with your global mobility partners and HR team members with respect to this even more complex and complicated area? And with the increased investigations by DOJ's Immigrant Employee Rights section.
Yeah, they really have been doing more investigations. So talk about document abuse and unintentional national origin discrimination. Employers need to be very careful that they're not asking questions that infer or pertain to national origin. If an applicant or somebody who's onboarding feels that they are being discriminated against based on their national origin, they can file a claim to the Immigrant and Employee Rights section of the Department of Justice. And recently, there have been investigations and prosecutions of companies who have been found to have unintentionally discriminated against U.S. workers. And U.S. workers include asylees. So if somebody was granted asylum, that's a U.S. worker. And some employers may accidentally or unintentionally advertise their position only available to U.S. citizens, and it wasn't warranted. So that there's ever a question about, in the interview process or the candidate vetting process about, somebody's background, just loop us in, loop in an immigration attorney, and we can help you make sure that you're asking acceptable questions. Of course, there are questions that are acceptable, but there are limitations, and we can help you with that.
That's really good information. So we're coming up on our last hot topic, which is it's February 2024, and COVID seems like ages ago, but we had, I know, yay, hopefully we don't go through that crazy process again. But moving forward, right, we had that period of time from March 2020 through July of 2023 when employers could do a virtual inspection of documentation to complete the I-9 process under the government's COVID-19 flexibilities. That flexibility period ended July 31st, 2023, and companies had until August 30th of 2023 to conduct a reinspection of their I-9s in order to be fully compliant with the government's provisions related to the COVID-19 flexibilities ending. So what are you seeing and what are you talking with your HR partners about for those who may not have even started the reinspection process yet or who haven't finished it yet?
Do it. Do it. I think a lot of companies didn't have the resources last summer to update their I-9s and implement the compliance steps the Department of Homeland Security required before doing what we now are very accustomed to in virtual verification, what I'm going through right now with virtual verification. One thing that I point out to employers, HR, global mobility groups is that Department of Homeland Security gave employers a grace period. So they gave employers a 30-day grace period. So you better believe that they're going to come back and say, you had a grace period to update your documents and you didn't do it. And so the fines could be really large. The bigger the company is, the larger the penalties, the more aggravating factors to increase the penalties, which can be, hundreds of thousands or more dollars. It's never too late. Employers who act in good faith to remediate errors, even late, that's a mitigating factor. So that can reduce the penalties and the fines. And not to mention there's a 5-year statute of limitations. So if companies go in and fix those deficient I-9s now, in 5 years, they won't be seen as a substantive error. So even better late than never, and show that good faith because it's a mitigating factor.
Really good advice. I wholeheartedly agree with that, right? We want to make sure that employers are protected. Mm-hmm. So with that, we're done with our hot topics for February 2024. If you have any questions, please put them in the comment section or send us a direct message. And tune in to WR Immigration's future LinkedIn Live programs and follow us on your LinkedIn. Thank you very much. Good to see everyone. Thank you, Carrie, and welcome to WR. We're excited to have you.
Thank you. I'm so happy to be here. Thank you, Kim. Thanks, everybody.